Today's webinar, Sales Tax 101, brought to you by the TaxConnex team. Today's topic is all about understanding sales tax nexus and what to do about it. My name is Liz Brigson. I'm happy to be here as your host, and I have a few announcements to help you get the most out of today's program. So first of all, if you want to use the questions feature and go ahead and say hello, that lets us know you can hear us and you know how to interact with us and ask questions. So hello to Tony, joining us from Orange County, California. Welcome, Kayla. Hello. Thanks so much for saying hi. Jared from Atlanta, Marjorie coming to us from Texas. Hello to Isaac and Terry, Paul, Brooks, East Coast, West Coast represented. Great to have you all here. You can download the presentation slides from the GoToWebinar control panel. If you'd like to hang on to those, reference them, share them with your team or colleagues. And of course, today's webinar is a CPE webinar. So that means you will have an opportunity to respond to polling questions. You'll want to respond to at least 3 of them. We hope you'll respond to all 4. And for those who qualify, you can access your CPE certificate from your Incorsa dashboard. If you're on LinkedIn, I'd love to connect with you. And I also would highly recommend that you follow the TaxConnex team for information and fun to see where their team is headed and the thought leadership that they have to share. It's my pleasure to welcome back Brian Greer and Jeff Meggs. They are both partners with TaxConnex. Brian is the Chief Revenue Officer. He helps companies manage sales tax risk by implementing sales tax outsourcing solutions and provides advice on sales tax issues such as Nexus, taxability, audits, voluntary disclosure agreements. Brian has a lot of experience in this field, and you will see that in today's program. Brian is joined by Jeff, who is the consulting practice leader. He's been with TaxConnex for over a decade, and he has really helped to grow TaxConnex through a focus on client experience and client satisfaction. Before joining TaxConnex, Jeff was a vice president with Thomson Reuters, and he's also worked with 2 of the big 4 firms as both a manager and senior manager. So, in addition to that, Jeff will share some stories sometimes as well from his experience as an auditor with the North Carolina Department of Revenue and on the corporate side as well. So these gentlemen have really sat on all the different sides of the table from a tax sales and use tax perspective and have a ton to share. So gentlemen, I'll go ahead and turn things over to you, and thank you so much for being here with us today.
Yeah, thanks, Liz. This is Brian, and welcome everybody to the webinar today. And I guess the question du jour is, how cold is it where you are today? Hopefully everybody's staying warm, especially here in the South and East Coast, all the way up through the Midwest. We had that pretty scary winter storm that came through recently, but hopefully everyone's making it through that. Let me dive into the agenda here, and then we'll pull up a polling question, and I'll kind of come back and talk a little bit more about Jeff and myself and TaxConnex in general. But, kicking off the beginning of the year here, thought it'd be a good idea just to kind of talk about getting your sales tax house in order, essentially. That usually starts with understanding where you have Nexus, where you have taxable sales, just getting yourself into compliance. You'll see another topic in here. We'll talk about exemptions and really kind of the difference as well between an exemption and an exclusion. And then talk about once you've identified that you have Nexus, you've got taxable sales, you know whether or not you have exempt customers and how to manage that process. We're going to have to get registered for sales tax purposes as well. So we'll kind of wrap up with that sales tax registration discussion. So Liz, I'll let you pull up the first polling question. We'll leave that open for a bit, and then I'll tell the audience a little bit more about Jeff and myself and TaxConnex.
Awesome, that sounds good. Here's our first polling question. How do you typically keep up with updates and changes in legislation surrounding tax?
Yeah, so if you've not been on our webinars before, I think Liz gave a real good background on myself and Jeff, but the 2 of us, we've worked together for somewhere in the range of about 25 years or so. It's very scary for me to think that I've been in sales tax for 25 years. Never really planned it. I don't think you planned it either, Jeff. It's just you kind of get into it and you can't get out. But we've both had a lot of experience over the years. TaxConnex specifically, if you're not familiar with our organization, I kind of think about what we do and sales tax for that matter in three different categories. The first is the consulting or advisory type of service or capability that we provide. A lot of what we'll be talking about today kind of fits into that consulting bucket, which is the part of TaxConnex that Jeff manages. But it's really helping companies understand what their sales tax requirements are, whether they have any type of risk or exposure from a sales tax perspective, and what they can do to remediate that risk and essentially get into compliance. The second area that I usually talk about from a sales tax perspective is the ability to get sales tax added to an invoice or applied within the shopping cart itself. So we provide a software solution that integrates into those billing systems, into those shopping carts to make sure the sales tax does get applied in a more automated fashion. And then the third area of sales tax where we focus on is more of a recurring outsourcing service, kind of a fractional sales tax department, but plugging in as that ongoing sales tax resource to support you with preparing and filing returns and managing sales tax registrations and kind of that go forward path. So that's the TaxConnex commercial for the day. Liz, if you want to end the poll there, we'll review the results and turn it over to Jeff here and we'll get started.
That sounds good. We can see the results up on the polling on the screen, and I'll go ahead and close that. So we're back to your slides.
All right. So Jeff, I'll let you get started here with our first topic of Nexus.
Thanks, Brian. Thanks, Liz. So, when we think about sales tax and the requirements, we typically start with a discussion about Nexus. Nexus is just the term we use to represent a connection between a taxpayer and a jurisdiction that would allow that jurisdiction to impose its authority, its taxing laws on that entity. And so from a sales tax perspective, and historically, we generally focused on physical activities, physical presence of activities, whether that be through employees or independent agents. And so going back in time, and we're going to talk a little bit about some of the evolutions of Nexus, but going back in time, we focused solely on the physical presence standards. And those standards included things like both real property, tangible personal property, and people. An office, an employee, inventory. Those were kind of the standards. And those were easy to kind of understand and comprehend for most taxpayers. But there were other activities that were deemed physical presence in a state that could trigger Nexus. Those being traveling sales reps, those being attendance to trade shows, somewhat infrequent activities and not permanent in nature, but still they were designed to create a market for a particular taxpayer. And establishing a market is, in a physical presence, is leveraging some of the infrastructure that taxpayers pay for, like roads, like airports, like security, the ability to flow freely from state to state in order to establish a market for your products and services is usually a Nexus creating activity. The last one I'll talk about is the one that probably catches people by surprise even today, and that is the leveraging of a third-party contractor or an independent agent. In some ways, companies are leveraging independent agents on a solicitation basis. But the one that really catches people a little bit off guard is when they are leveraging a third-party resource to perform a service on behalf of their customer. An example might be I sell copiers, and I've got 2 customers in Oklahoma that have purchased copiers from me, and they've also purchased maintenance agreements. And when one of those customers calls and needs a repair or needs somebody to come and check on the equipment, I'm unlikely to want to fly somebody in my organization to Oklahoma to execute that repair. So I might leverage a third-party resource, a third-party repairman local to that community, to go in as a representative of my company to effect that maintenance agreement. That activity, that leveraging of that resource, is considered a physical presence within the state. Notwithstanding the fact that you don't own that resource, you are, in fact, to some extent controlling that resource. And again, it enables you to maintain and create a market for your products and services in that state. So that's the way Nexus was really interpreted for the vast majority of the time that I've worked in sales and use tax. We go all the way back to 1967 with a court case referred to as National Bellis Hess versus Illinois. And we fast forward into the early 90s when the state of North Dakota started to pressure some vendors, in that case Quill, to register and comply with their sales tax laws. And the states were simply pushing the envelope in terms of aggressiveness around these tests, whether they be physical presence and evolving into more of an economic test. So even in those days when it was primarily physical presence, we saw states getting increasingly aggressive, and we saw some things that were starting to really raise eyebrows. We saw things like click-through nexus, otherwise referred to as the Amazon law in the state of New York, where New York said, look, if you've got a person who owns a website that's physically present in the state of New York, and you have a banner on that website that allows for one of their customers to click through and access your market online, and you pay that web host some fee when there's a transaction, you're leveraging an in-state resource for purposes of sales tax nexus. And that was a trigger that really started to play out favorably or unfavorably, depending on which side of the fence you stood. There then started to become these sort of notification requirements that were onerous, in my opinion. Onerous, by the way, is what I meant to say. But Pennsylvania, Colorado, they kind of started something like this. And what they said was, if you sell more than $10,000 of product or service into our state, we're going to require you to do 2 things. First, we want you to put a statement on your invoice that says the customer is responsible for any use tax that might be applicable to the transaction. But the other part of the equation was, at the end of each year, you were to provide a list of those customers to the state. So those notification or reporting requirements weren't very well received, as you might imagine, by taxpayers and businesses. But the state said, well, there's an option. You can register and comply. You don't have to do this. If you simply register for sales tax purposes, charge tax on your invoices, and report and pay to the state. There were other scenarios. Cookie nexus was a thing. Cookies being those things that when you log into a retailer website, they will, in some cases, you can't even opt out of it, but they'll have these cookies, which are basically ways to make your experience using that website more feasible, reasonable, and efficient, especially if you're a recurring visitor to that website. And in that capacity, those cookies are downloading something onto your computer. And the state started to say, well, wait a minute, you're downloading some element of software that you own and to some extent control into a computer based in our state. We're going to deem that you have physical presence based on that cookie, that software language that might be sitting there. So there was a degree of aggressiveness that was happening, and this started really towards the end of the 2000s, in the 2008 timeframe, and rolled all the way into around 2015. And then we started to see a real push and evolution of the economic nexus standard. And so we'll talk a little bit more about that as we get through this poll question.
Just a quick comment or question related to those notification requirements, because I know kind of back in the day, because of the onerous nature of those notification requirements, I don't think a lot of people paid much attention to them, and we even recommended just register and start, collecting and complying, rather than try to even follow those notification requirements. Did those go away?
Yeah, and we'll talk about this a little more with the
it might be getting a little bit
of the economic standards. They've gone away.
Okay.
They're essentially no longer in existence, and those, along with some other things that were associated with Nexus, affiliate Nexus, for example. There were some things that once we saw this evolution to economic Nexus, we saw them be repealed.
Gotcha. That's helpful. So Liz, if you want to pull up that second polling question.
Yeah, that sounds great.
And then I've got a question here from the audience too.
That sounds great. Let me launch that second polling question. Do you plan to make changes to your compliance processes this year? So poll is open, and let's go ahead and attend to some audience questions.
Yeah, so this, Jeff, kind of falls back into that third-party contractor type of discussion, and Kayla's asking if they're utilizing third-party contractor to do some type of installation of a handrail that they make in another state, does that create Nexus? And if so, should they charge the third-party contractor the sales tax in that state?
Yeah, generally the way we would think about that type of transaction is that you have separately negotiated and engaged that third-party contractor contractually to fulfill that installation, and that you've also separately engaged with that customer for the purpose of both selling and installing that railing. So the customer, for the most part, doesn't really get involved with that relationship with the independent contractor. They view that independent contractor as you, as the person that's selling and installing that railing. So generally speaking, we would not expect to see, more often than not, we wouldn't expect to see a sales taxable transaction between you and that subcontractor. The sales tax typically would apply, and that question kind of rolls across a couple of different scenarios, and I may talk about this even later. But the sales and use tax implication would predominantly be the vendors, the customer, the vendors and the customer. Either tax would be charged on that invoice to the customer receiving the railing, or that particular vendor may pay tax on their materials directly to their vendors. And the service of installing the railing might be deemed a service, might be deemed a real property improvement, which in a lot of states isn't subject to tax. So long answer to a short question.
Yeah, it kind of spans like several different variables in terms of Nexus, in terms of, is it the sale and installation of tangible personal property? Is it an improvement to real property? But I think the short answer is that contractor, provided that your customer is hiring you to do the installation and you sub that out to that third party contractor is creating Nexus for you in that state where that service is being performed. And then we're going to get into some of the taxability discussions here in a bit, is kind of the next piece of that. Okay.
The results to the polling question are on the screen. Thanks everyone for responding, and appreciate you taking the audience question as well.
All right, let's keep moving here.
Yeah, so economic nexus, it's a real thing today for a lot of you on the call that are engaged in sales tax work at any level might be familiar with this next part of the discussion. It's been around now for going on 7 years plus. But in 2016, South Dakota sought to legislate an economic nexus standard. And what we're saying when we say nexus standard is it's based predominantly and almost exclusively on the generation of revenue from sales into the state. So it does not have any physical presence standard or test that applies to it. It is purely a revenue, but secondarily to that, South Dakota also introduced a transactional component. So it was an either-or scenario. Either you had $100,000 in revenue during a 12-month period in that state, or you had more than 200 sales transactions into the state of South Dakota. Either one of those would trigger Nexus for sales tax purposes, requiring you to register and comply to the extent you were making taxable sales of taxable goods. This was, again, sort of another evolution as we talked about the cookie nexus and the click-through nexus. The standard of economic nexus was historically deemed too difficult for vendors to comply with. And the matter was really associated with the fact that if I'm selling into 50 states and I've got to comply with all 50 state sales tax laws, knowing that they're somewhat different, knowing that there's rate differences, there's different levels of tax and different jurisdictions, there's just no feasible way for an interstate company to comply with all of that without making them have some degree of commitment to the state in a physical presence standard. So this South Dakota law was kind of, it not only was new and fresh, but it was deemed aggressive by a lot of people. And ultimately what South Dakota did in their legislation was to create an avenue by which this law could be challenged relatively quickly and efficiently and go through the courts. Because as you can imagine, once this legislation came out for those companies that were selling into South Dakota materially, it became an issue that they were worried about. Do we comply or do we challenge it? Or do we wait and see what happens? Well, along comes Wayfair. Wayfair, being an online retailer, was operating in a capacity that didn't include physical presence in South Dakota, but South Dakota leveraged this new legislation and asserted Nexus to Wayfair and assessed them sales and use taxes on their sales. Wayfair challenged it. It went up through the South Dakota Supreme Court, and in that avenue, the taxpayer won. The South Dakota Supreme Court deemed this to be unconstitutional and in conflict with the Commerce Clause, the U.S. Constitution. And so Wayfair was victorious, or so we all thought, until the state of South Dakota asked the U.S. Supreme Court to hear the case. And the U.S. Supreme Court had been asked previously to hear some of these cases, had dabbled in this a little bit. There's also been some congressional and other federal legislation proposed along these lines. But this particular case was heard by the U.S. Supreme Court. They heard the arguments in April of 2018, and in June of 2018 ruled 5-4 in favor of the constitutionality of South Dakota's economic nexus law. In doing so, you might imagine that there were a lot of states that were supporting South Dakota. They were kind of behind the scenes, probably funding some of the legal representation, but also gearing themselves up for a potential victory or windfall. At the same time, there were certainly participants on the Wayfair side that did not want this to happen. Interestingly, though, not all companies were on Wayfair's side. There were a lot of companies, some big box retailers, in fact, that wanted to see something like this. They wanted to see a level playing field, and none more so than the small retailer, the person that's operating on the corner of the street down somewhere in South Dakota, who's responsible for charging sales tax on everything they sell, yet their competition can come in on a website and undercut them, or at least compete with them in a way that wasn't seemingly fair. Ultimately, though, we now have, as of June 21st, 2018, we have legal authority to legislate an economic standard for sales and use tax nexus purpose. And that's exactly what all the states did. As we look at it today, every state has an economic nexus standard. Not all of them happened at the same time. There was sort of an evolution of different legislation being passed at different times for different states. The majority of the states did adopt something very similar, if not exactly like what South Dakota legislation proposed, and that was $100,000 or 200 transactions. But that wasn't the way all states went about it. There were a number of states that chose not to legislate the 200 transaction threshold. There were some states that actually more granularly defined what that revenue needed to be. It needed to be sales of tangible personal property, perhaps, like in California. And on top of that, California set a threshold of $500,000 instead of the $100,000 threshold. There were other states like New York and Texas that had $500,000 thresholds and some unique circumstances. All in all, eventually, by the time we get to January of 2003, it took that long for the final state of Missouri to enact their legislation around this and activate the economic nexus standard. Now, what's important to understand about everything we just talked about is the physical presence standard didn't change, didn't go away. The economic principle and standard is on top of and in addition to any physical presence standard. So you've got to take both into consideration. What I like about this legislation is it does at least draw a bright line for a lot of states to look at the law around Nexus in some states. There was a lot of ambiguity about the physical presence. Certainly no ambiguity when I've got inventory or I've got an office or I've got employees in the state, but there was ambiguity when it came to how many days attending a trade show does that have to be before I have Nexus or I'm deemed to have Nexus for sales tax purposes. How many days can my sales rep visit the state and solicit before a Nexus is established? And a lot of states really didn't give any good guidance in that regard. So a lot of companies were left to guess and interpret. There was some case law out there, and there were some states that were pretty specific, but at least this economic nexus standard was more or less a bright line test. Did I meet it or didn't I? And in addition to each state kind of coming into their own when it comes to legislation for economic nexus, there are some continued nuances out there to be aware of. First of all, there are 5 states that do not have a state level sales tax. And if you're looking at the map on your screen, you're seeing those states grayed out. Those are Alaska, Delaware, New Hampshire, Montana, and Oregon. It does happen that Alaska has a number of cities that we call home rule cities. These are cities that have their own administration of sales tax. And so there are cities in Alaska that impose a sales tax, and those cities have come together and created a coalition that established an economic nexus principle. That principle being, if you sell more than 100,000 into the state of Alaska, you're going to have nexus with those local jurisdictions and have to comply. There are a couple other states that kind of fit into this. Colorado being probably the one that tends to give most people the most headaches. There are about 73 home rule cities in Colorado. They've established a similar rule that I just spoke about with regard to Alaska. If you establish economic nexus with the state of Colorado, you in turn establish nexus with each of the local cities that administer their own sales tax within the state of Colorado.
So Jeff, I think you shared also, kind of moving on to the next slide here in terms of the physical presence and the economic presence, just really kind of complicating things rather than clearing up the situation for companies and taxpayers. And I've often had that cynical perspective that whenever the government gets involved, it's normally going to get more complicated. and not necessarily simplified. And that's exactly what's happened here. And even taking that a step further, when you start to look at some of the streamlined sales tax simplification activities over the years, while it's somewhat simplified sales tax in certain states, it's also complicated it. And Colorado is a good example of that with this RDF fee that they've implemented, the retail delivery fee. So while sales tax has gotten maybe simplified in certain states, these economic nexus standards added another layer. Colorado implementing this retail delivery fee that's really not a sales tax. That's an added layer of complexity here as well. So Liz, I'll let you do the next polling question here, and then a couple of additional comments and questions here.
Very good. Here's our next polling question. Which of the following reasons explains why you don't outsource your sales tax management? So maybe more than one might apply, but please go ahead and choose the most important reason. So we'll leave the polling question open, and let's take a look at some audience questions.
Yeah, and even before I pull up some of those questions, a couple of additional comments as we're kind of wrapping up this Nexus part of the discussion. The transaction counts that Jeff referenced in terms of the 200 individual transactions sourced into a specific state, we've really started to see a lot of states do away with those. Even South Dakota repealed that, I think, in 2025, with kind of the idea or the concept being, I might have a 200 transactions that are worth $1 or worth $5. It's a very limited revenue scenario, and the economic nexus standard was really agreed to or voted on at the Supreme Court level, where this was something that would not necessarily burden the interstate commerce. And when you start looking at that transaction count threshold, it really opens up the opportunity for challenges where that puts a significant burden on smaller businesses. So eliminating those transaction counts kind of eliminates or really focuses the efforts on quote unquote larger businesses that have at least $100,000 of sales into those states. So we've seen a lot of those transaction count thresholds go away. They're still in existence in some states, but pay attention to that as well. Let's see, looking at some questions here. So what do we do with the sales tax if we do not meet the threshold? So hopefully you've not collected the sales tax until you've met the threshold. That's kind of the main concept here, is that if you don't have Nexus, whether that is a physical presence or an economic presence, that's kind of the end of the discussion for sales tax purposes. So if you don't have Nexus, you don't have an obligation to collect the sales tax. Now, if you are in a scenario where you have collected the sales tax, it's I would say a requirement, necessity, obligation that you do one of two things. You either have to register and report that sales tax to the applicable states, regardless of whether you truly had Nexus or not, or you've got to refund that tax to the customer. You can't sit on that sales tax. It's a trust fund. It's the state's money. It's the one thing that you can probably go to jail for, is collecting sales tax but not reporting it. So hopefully you don't collect it until you have Nexus. If you are in that situation, you got to report it, or you have to refund it to your customers. One other question here before we move on. If I have a single employee in the state, Jeff, is that enough to create a physical presence for you?
I would say generally yes. The way we look at Nexus when we consider physical and economic standards is we apply a materiality threshold to it, a risk quotient. So if I've got an employee in the state, but I'm only generating $25,000 in revenue from that state, I might decide I'm not even going to pay attention to whether or not I'm providing a taxable product or service. I'm just going to ignore it. It's not material. It's going to be too costly to comply as compared to the risk. So it is sort of a multifaceted evaluation that you want to go through when you're trying to determine Nexus. I would say that you should consider and deem yourself to have established Nexus with an employee. Now, it is true that in more or less historically, we would say if that employee was not critical to establishing or maintaining a market in the state, they were doing a back office function, we would argue in some cases that that wasn't Nexus creating. It wasn't a strategic placement of an employee. It just happened to be where that employee worked. And of course, over the last 7 or 8 years, we all know that there's more and more of this remote officing. Employees based in just about any place can work for a company. So it is a little bit of a challenge. And it's another reason I kind of applaud the incident of economic nexus, because it kind of puts us back into that materiality analysis rather than the physical presence test. But yeah, it does. I think it would.
Yeah, and it's a good point, because we often get into these discussions about the kind of the letter of the law as to whether you've got Nexus and taxable sales versus should you comply. And those, depending on the business, those might be two different answers based on the materiality and the risk tolerance of the business. And oftentimes we're working with companies that they might be fairly new, and they're trying to establish a revenue stream and trying to establish a business. And I think you said it before, Jeff, if you're 100% compliant, you're spending way too much money being compliant.
Yeah, I use a lot of silly analogies in some of my commentary, and I use this one on a lot of occasions. I find it, living in the Atlanta area and using some of the road systems and traveling around the city, very, very, very few people are following the speeding assignment around Atlanta. It's rare that you can find somebody driving 55 miles an hour around 285. That's kind of the way I think about sales tax. I think that there's, this is you've got to do the right thing as a business. So we're not encouraging non-compliance when we say this, but we also are focused on building the business primarily and making sure we've got a profitable business that has an ability to sustain. And in the long term, we are going to encourage compliance. We are going to encourage registration, and voluntary compliance is really the way sales tax is established in all the states. There's very limited resources to go out and audit every company that's out there operating without a sales tax license. The last thing I'll say about the employee is if you do have an employee there, recognize that you've got payroll taxes more likely than not, and that puts you on the radar. And so it gives a state an opportunity to pretty efficiently and not very costly send out some notices to you and ask you some questions that are hard to answer.
And then you got to try to prove that you don't have Nexus.
Yeah,
and that becomes a lot more challenging.
It becomes very expensive. It becomes very expensive.
Let's move on to the taxability piece here.
Yeah, so we spend a ton of time, obviously, on Nexus, and we did that because our experience says that's really the first step in making any effort to comply for sales and use tax purposes. As Brian said, if you don't have Nexus, there's nothing to worry about. And the other reason is, if you do have Nexus, determining taxability can be very straightforward, but it can also be very complicated, particularly if you're operating in a lot of different states and you have some unique products. In a general sense, the states that do impose a sales tax do so on the retail sale of tangible personal property and enumerated services. those enumerated services have grown over the course of time, and a lot more services today fall within the framework of taxability than we used to see 15 or 20 years ago. So the states do have a little bit of ambiguity and uniqueness when it comes to Nexus. There's a bit more ambiguity and uniqueness when it gets into the taxability requirements. And that's true not necessarily for any one business in and of itself, but Brian and I, we work across a spectrum of companies that do all sorts of things. And as you heard in our answer to the railing question earlier, there's a lot of what ifs or if-thens. And so depending on what type of business you're in, what type of activities you engage in, the taxability can be extremely simple, and it can also get very complicated. Tangible personal property, again, being sort of the baseline for all sales tax applicability. Services, again, it's okay to have a perspective that most of the time services aren't taxable, but be very careful. There's a ton of services that are taxable, some of which a lot of us on this call would call consulting services or professional services. So I just caution you not to get too comfortable that services are not taxable, particularly in technology. A lot of services that are ancillary to technology and software can become taxable just by way of being associated with a software application. The other thing that's very challenging and another added layer of complexity when we're talking about sales tax compliance is situsing. Now, we've gone down a path of determining where we have Nexus. We kind of understand the taxability of our products. Now we have this transaction that involves maybe a common carrier who's coming to pick up property from my warehouse and deliver it to my customer in a certain location. And the situsing question for purposes of where does the tax apply, if at all, comes into play. And that can be real challenging, especially when you get into services. Software as a service is a classic example where it's not uncommon for a company to sell 100 seat licenses to a headquarters located in New York City. New York does tax SaaS, but those particular seats might be used in a bunch of different states throughout the country. Some of those states may not tax SaaS. And so there's some unique circumstances in those transactions that have to be accounted for or may need to be accounted for. So taxability starts to get a bit more complicated, and that's why it's important. If you don't have to go down the path of evaluating taxability and you can avoid it by avoiding Nexus, you're in a better place.
So Jeff, I'm going to jump in here with a question that I think fits exactly with what you're describing here. And Steve has this question about, can a customer request to take delivery in a non-sales tax state to avoid the sales tax? It's kind of a situsing related question there.
Yeah, sure. Yes. The short answer is yes. What you might be thinking about is, I'm going to take possession in Delaware, and then I'm going to drive across the border and use it in one of the bordering states, which would be extremely easy to do in a state like Delaware. The states are wise to that. There are a couple. Look at the Tyco CEO. If you want to look at some cases where somebody tried to finagle where situsing occurred and didn't play out so well for them. But yeah, you could do that. It's probably unlikely that, if you're going to have a business that's ongoing and meaningful, that's not a long-term strategy that's going to work for you. When you bring that product into the other state, what happens is it becomes subject to consumer's use tax. And now as the consumer of that product, you've now inherited the tax responsibility for both calculation and reporting and remittance.
But as a vendor, if I've got a customer that says, I need you to ship it over here, and it's in Delaware, and Delaware doesn't have sales tax, as the vendor,
you're done.
I'm good with that.
Yep.
It's the buyer that really takes on the responsibility if they deploy it in a different state at that point.
Exactly. That's exactly right.
Perfect.
The next couple of slides are going to be talking about some of the exceptions to the rule. So the rule being retail sales of tangible personal property are subject to sales tax. What are the exceptions to that? Well, there's special entity scenarios. The federal government is generally exempt in all cases when it comes to sales tax. Now, be careful if you're operating in New Mexico. New Mexico's what we call sales tax, and I've got my quotes in the air here, is really a gross receipts tax. And so even though you're selling to the federal government, you could be subject to that New Mexico sales tax, i.e. gross receipts tax that they have in place. Similarly, Hawaii can have a little bit of that action as well. In a lot of states, the legislation provides that sales to a state or local government are statutorily exempt. Most of those states do require that that state or local government provide an exemption certificate. The federal government, sales directly to the federal government generally don't require any type of documentation other than the fact that the invoice is directly to that government agency. We get into a few other scenarios, nonprofit organizations. There's a number of states that provide exemptions for nonprofits. It's important to note that not all states will exempt sales to the state and local government, and fewer states will exempt sales to nonprofits. And so in the nonprofit category, you absolutely need to get some type of documentation supporting it. The last three that you see on the screen, resellers, manufacturing, and agriculture, these are industry segments. Resellers, not so much industry, but resellers are in a position where they can issue resale exemption certificates in order to buy tangible personal property exempt, recognizing that that's ultimately going to end up, let's call it a Walmart shelf that someone's going to walk in, pick it up, pay for it at Walmart. Walmart's going to charge the tax on that transaction. Manufacturers are afforded a lot of exemptions when it comes to particularly raw materials, but also manufacturing equipment. And then in the agriculture arena, there's a number of exemptions that can be achieved depending on the state. The point from this slide is that there's a lot of variability. There's a lot of, if you're selling to a lot of different types of industries, a lot of different types of customers, you can find yourself in a little bit of an overwhelming situation trying to navigate who's exempt, who's taxable, where's the transaction occurring, do I have Nexus, all of those things play. As we talk about exemptions, and as Brian said earlier, exclusions, the primary difference between an exemption and exclusion is an exclusion is something that was never set forth as a taxable event within the statutes. So if you don't ever have a statute that says that tangible personal property is taxable, then it's excluded from tax. And when it's an exclusion, such as the service that Brian and I provide here in Georgia to our customers, it's excluded from tax. The state does not legislate that services of the type we provide are taxable. So we don't have to get any type of exemption documentation from our customers when we bill them. We simply don't charge tax, notwithstanding the fact that we clearly have Nexus here in the state of Georgia. Exemptions are transactions that would otherwise be taxable, but for the type of customer or the type of transaction that's involved. And that brings us back to the prior slide. If you're selling to a reseller, that's an exemption. And the exemptions, the key difference here is that I've got to support an exemption with a document. We call it an exemption certificate. They come in a lot of different forms, a lot of different flavors. They're not all consistent from state to state. Some states use a specific type of form. Some states will allow you to be flexible and use your own letterhead, so long as it has the correct and total attributes that are necessary to achieve that exemption. So again, we have exemptions and exclusions. Exemptions generally are going to require some degree of documentation to support them. The vendor has to collect that documentation and maintain it, and then under audit be able to supply it to an auditor to substantiate the exempt treatment of that customer. Professional services is a term that is used, I think, a little bit too casually across a lot of the companies we talk to. I consider professional services to be one of five things: accounting services, a CPA, law services, medical services, architects, and engineers. Those services, those people that provide those services are educated specific for those services, and they're licensed for those services. Those are what I consider professional services. Everything else is some type of service, but I caution you not to use professional services because professional services are generally excluded from tax across all the states, notwithstanding the Hawaiis and the New Mexicos of the world. So it's very common for our clients to come to us and say, hey, we're providing professional services in Ohio. Is that taxable? Well, my natural answer is, yeah, I think it's exempt. But I don't answer that question without going, what exactly are you doing? What type of service? Well, we're installing something. Well, installation services might be taxable in any number of states. You can't put that in the same category as a professional service. The last piece of this discussion today, again, kind of recapping, as we think about sales tax compliance and the requirements, first we look at Nexus, second we look at taxability, third we consider our client base. Is our client base generally an exempt entity, or are they using our product or service in an exempt fashion? If it lines up that I have Nexus, I have a taxable product, and I have taxable customers, now I've got to consider compliance. And sales tax compliance it's a process. It has a number of different steps that you have to execute. Once you get the process in place for a single state, it's fairly easy to translate that process to other states. That being said, there's some tricks, there's some places in the process that you need to account for. As we talked about earlier, we like to evaluate the materiality. We like to think that if we're going to invest in a compliance process, it's because we have a requirement to comply, and it's more likely than not somewhat material. When we think of non-compliance, the thing that comes to mind for me is, hey, I've got Nexus, I've got a taxable product, and it's relatively immaterial. I'm only selling $35,000 a year into that state. Okay, you might skip the first year, you might skip the second year, but keep in mind that there is no statute of limitations running if you're not registered and compliant. So a state can go back 7 to 10 years, and over that period of time, that $35,000 might become material to you in terms of an assessment, and where they are also going to apply penalties and interest. So keep in mind that you do not have the benefit of a statute of limitations until you're registered. When you are complying in some of these states, like the Colorados, the Louisianas, the Alabamas, there are some of these city level taxes. Chicago, Illinois has some special taxes to be aware of. So there is some both state administered registrations that you have to execute, but there also could be some local registrations that are required. And then some of the reporting requirements when you've got the local home rule jurisdictions in play can be a little bit onerous. Effective date, why are we even talking about that? Well, I may know that my effective date, the date that I deemed myself to have Nexus and I have taxable products, that might have been 1.5 years ago. And when I go to register with that state, there is going to be a question on every state registration that says, when did you first have taxable sales, or when did you start business in our state? If you put 1.5 years ago, if you put January of 2023 in that field, the state is going to auto-generate notices to you requiring you to file returns for every period, and likely monthly, from January 2023 to current. And they will assess penalties and interest on those filings. It's a very common practice when companies have been doing business for a while, they have had Nexus and they have made some taxable sales, but they haven't charged and collected tax. So they're not holding funds of the state, and they do want to comply, but they're in this tricky position. How do I answer that question of the effective date? It is very common to use a current date or a prospective date in those circumstances. Now, it doesn't absolve you of that liability in the past. The states can still come in and audit and assess you for the past. But what we haven't seen in the probably 20,000 or more registrations that we've done that fit into this category is a state come back to try to pursue some type of criminal perjury against a registrant. That just doesn't happen. And I've got some stories I could tell, but I know for the sake of time, we'll kind of try to wrap up this particular slide. It's important you understand the tax type, and you might be saying, well, duh, it's sales tax. No, it may not be. In some states, you have a different registration and a different form when it's use tax. And use tax can be retailer's use tax or consumer's use tax. So I could be selling into the state of Missouri, and I may need to file the use tax form if I'm shipping from a point outside the state to a point inside Missouri. If I have a Missouri brick and mortar location, I'm going to register and file the Missouri sales tax return. So there are different tax types, and you want to be aware of which tax type you're registering for. It can have implications on your statute of limitations in the long term. The other thing that really catches a lot of people by surprise is when you register, you are going to have to provide at least one corporate officer and their social security number. The states want to have a hook into somebody who's responsible for the taxes that are being collected by that company that, to Brian's point earlier, become trust funds and need to be reported and are the possession of the state. The rest of the process is navigating the portals, the various portals within the states, which, as you might imagine, some of them are great, but some of them are a real hassle, a real challenge, and they put a lot of pressure on anyone trying to manage compliance on a multi-state environment. The last piece of this, which is maybe the most important, now that I think about it, is tax calculation. You might be in a position where you can handle tax calculation more manually or through your ERP system, but there are also some sophisticated bolt-on solutions or interface solutions that can be leveraged for sales and use tax compliance and tax calculation. They also handle citing and rates and things of that nature.
All right, so Liz, we've got a couple of questions here if you want to pull up the last polling question, and then we'll take an audience question or two and wrap up here.
Sounds good. If you, the audience, are interested in learning more about TaxConnex, we would highly encourage you to do so. You can go ahead and let us know in the polling question. I'll leave the poll open, and I'll turn it back over to you, Brian.
Yeah, so I think the one question we took earlier about collecting the sales tax and either reporting it or refunding it to the customer, looks like Kayla's got a follow-up question from that. And I would suggest that we touch base with you offline on that, because there's a lot of nuances in terms of, we collected that tax a year and a half ago. Do we have to state at what point we collected it before we report it? We're probably going to get into a materiality discussion there of how much sales tax did you collect, because yes, again, this goes into what's the letter of the law versus what's practical. You should go back and report that based on when you collected it, but as soon as you do that, you're 100% going to get hit with some kind of penalty, interest as well. Again, depending on the materiality of it, it might be something that you're able to just remit it on a current return. But again, there's a lot of nuances and very specific to your situation that we could talk through to give you the right answer there. Last question that I'll throw at you, Jeff, and Seth brought this up. I was already thinking about it in my mind to ask you at the end, but it's related to a company that has Nexus. They have exempt transactions. And let's assume we've gathered all the applicable exemption certificates, which is an important piece of this. So I don't have any tax to report. So I've got Nexus, I've got no tax to report, got all my exemption certificates. Should I register and file a tax return?
Yeah, we see that a good bit. And depending on the overall circumstances, there are occasions where we will advise a client that it's probably not necessary to register under those conditions. Now, there are risks associated with that, and there are certain states where that's feasible and appropriate, and other states where it's not appropriate. There are some states that have some basic filing principles or requirements that will impose penalties for just a failure to file a zero due return, and those accumulate. could be other scenarios that play out unfavorably under those circumstances that a little bit beyond what I think we want to talk about today. But generally speaking, I would say that in a lot of cases, we don't encourage registration under those conditions for a lot of the states, not all of them. And it's a real specific circumstantial question.
Yep, makes sense. Liz, I'll let you wrap up here for us.
Thank you so much, Brian, and thank you, Jeff. Really appreciate everything that you shared today and taking so many audience questions. To the audience, thanks for your engagement. Want to give you the quick closing reminders. When you close GoToWebinar, a course survey will pop up on your screen, and we always read and appreciate your feedback. You'll be able to access the recording of today's program from your Incourse dashboard a little later on. Your CPE certificate will populate to your dashboard in about 1 hour, and the slide deck is also saved to your Incourse dashboard. So we really appreciate you joining us today. Take a look in the follow-up email for the link to register for February's program, which is going to be Sales Tax 102. So again, that link will be in the follow-up email. Thank you, everyone. Hope you have a great day. Stay warm, and we'll talk to you soon.
Thanks, all.